Good afternoon, everyone. Today is the 18th of July. My name is Sasha Hodder. This is the HODLcast, and today we're going to look at the Centra Tech Incorporated ICO. Before I did a little piece on this that had to do with the SEC complaint and the criminal complaints against them for securities fraud. Today we're going to look at the civil class action against them and the implications of what just happened. The judge declared that these ICO tokens were securities. So basically, this is the first time that we've ever had this declaration that something actually is a security in court. There's been a lot of alluding that this would be the case, but it's never actually happened yet. So this is the first one. So Centra Tech, they did their ICO back in the summer of last year of 2017. It ran from July 30th until October 5th, and they raised $30 million worth of ETH and Bitcoin. And they said they were selling a bank card that would use crypto, and the whole thing was a fraud. And I went through kind of every bad act they did in my other podcast a while back, so I'm not going to rehash through that, but you can trust they did a lot of egregious actions, like they made up fake advisors, things like that. So on June 25th, 2018, Judge Andrea Simonton issued a report where she recommended finding these CTR Centra tokens to be investment contracts. So that is the same as calling them securities. So it was a 19-page report. The highlights of it, basically the arguments on the plaintiff side were that Centra should lose on the arbitration provision. So I guess Centra had already put in something saying they wanted to arbitrate this and have it decided, in binding arbitration outside of a court. And that would have prevented us from getting this public opinion that these things are securities that, you can imagine is going to get used as precedent in a lot of other cases. It's not actually precedent just yet. It's just dicta, but it's there. It's the first time it's in a court. So they argued, that they should lose on the arbitration clause, but it turned out Centra, the same way they messed up in so many areas, they aren't able to produce any arbitration clause that their ICO investors signed. So, that argument's going to fail. And the fact that it's still in court, obviously, it failed. They also, on April 5th, they issued this, they said they need a temporary restraining order to prevent anyone from transferring the ICO proceeds. And they said that they got new information from the SEC's case that some of these assets are going missing. So they're suspecting that someone is taking the proceeds out of the wallet. So what happened was that SEC issued that I think it was 91,000 Ethereum that's in the main ICO wallet be frozen, and Centra agreed to that. And then the class action also requested on top of the temporary restraining order, they requested that there be an asset freeze on the defendants, and that would include Centra Tech and Sharma, Trapani, Farkas, and Hagner. And Hagner is actually deceased, so they also put it on his heirs. Along with their current, so this one was really broad. It made me wonder, Mayweather and DJ Khaled were big time promoters of this ICO, and the language here says, so those main people get the asset freeze, but it's also asking for an asset freeze on any of Centra Tech's current or former officers, agents, affiliates, and individual defendants, affiliates, representatives, and other relevant individuals, accounts, or digital currency wallets holding any of the ICO proceeds. So these people have not been named yet whatsoever, but to me, that's asking for their assets to be frozen too, because no doubt they for in exchange for their heavy promotion, they would have got some of the ICO proceeds, and promoter is an agent or an affiliate. So I I love Mayweather, but I won't comment there. I think we're going to see them dragged into this. And then they also have to make sure that the defendants keep their evidence intact. And the fourth thing is requiring that all defendants provide the court with a detailed accounting of their transactions pertaining to the Centra ICO proceeds. So this includes all their transfers, liquidations, purchases, and expenditures. So pretty much like every dollar they've spent of the ICO proceeds, they have to account for and show what they used it on. So if they went out and bought a Lambo or a new boat or something like that, we're gonna see it. Thank God it didn't go to arbitration, so we can watch it all, transpire. But also, in April 13th of 2018, in the criminal case for the Southern District of New York, the Department of Justice issued a warrant for the 91,000 Ethereum that's stored in the main ICO wallet. So today, the government already has that property seized, and then as a result of this, they found there was another wallet that had something like 8,000 Ethereum. So they voluntarily surrendered or agreed that that could be frozen as well. So the standard to get a temporary restraining order is really high. It's a very tough thing to win. They didn't win it here. What you need is you have to have a substantial likelihood of success on the merits in the underlying case. That I think they have. Like, the facts are pretty bad here, and we just, in this order, determined that they are securities. That would have been their only, if they could have determined that these things were not securities, nothing else would have applied. So they lost that right there. So they lost the fact that they lost their strategy of saying, well, they didn't even try to argue that, which I find crazy. But anyway, they just conceded that they were securities, and as securities, I think the substantial likelihood of success in the underlying case is very high. So that one, it should be passed. But then the second one, the movement will suffer irreparable harm in absence of an injunction. And that's the one that the judge said they don't meet because it's not really that harmful to them at this point, especially the main plaintiffs. They already sold their coins. So whatever happens to the proceeds in that 91,000 isn't going to impact them whatsoever because they already sold out. So they've already lost the opportunity for rescission. And then the third one is the harm suffered by the movement in the absence of an injunction would exceed the harm suffered by the opposing party. So that one here is not like a huge harm on the opposing party. That prong is usually for if it's like you're putting a temporary injunction on a construction project or something like that, and it's going to cost a ton of money to stop everyone from working, and the only reason that the person wants the injunction is because maybe it's noisy in the construction zone. So then the weight of the noise issue compared to the cost of stopping construction is going to be more, it's like too much harm on the defendant without enough harm on the plaintiff. So it's kind of a balance. And then the last one is that the injunction would not disserve public interest. So again, that's usually like if it's, they're building a fire station or something like that, and they want to say, oh, we've got to put an injunction on this fire station because it's noisy while you're building it, or some silly thing like that. Or they say, we think it should go in a different area of town, or, maybe the only thing that they could get that to stop construction on would be like if there's an endangered species, then they look at, what's the overall public interest? Is the fire station more important than the endangered species that it's going to kill to put the fire station there? So that's way off topic, but that's typically like the analysis that is used for an injunction. And so Centra responded to this whole thing by agreeing to restrain from accessing the proceeds of the wallet. Like, oh, big, that's real hard for them while they're sitting in jail and while the government has the proceeds of the wallet. So that one kind of makes sense. And then they also did give up the new wallet that had 8,932 Ethereum. So they are being fairly cooperative here. Probably, they're being highly coaxed into cooperation while they're in jail. But maybe they're out on bond. I don't know for sure. I know they were arrested. I don't know if they're still in jail waiting for their trial or proceeds of that thing. So they're probably out. But anyway, they're being cooperative. And then, so the meat of this, the reason I took the time to do this is the Centra tokens as securities. So they just conceded that these are securities. They didn't raise any arguments against it. And then the judge decided they did say that they'll reserve the right to challenge this at a later time if that's necessary. And then the judge basically analyzed it on her own, and she used Florida case law, which, the big infamous Howey case is from Florida in 1946. So there's been a lot of Florida case law developed on top of that Howey case since then. And the case that the judge used was called Tippins versus Round Island Plantation LLC. It's a 2009 case in Southern District of Florida. And they also cited the SEC versus Unique Fin Concepts, which is an 11th Circuit case from 1999. And what they said is that an offering is an investment contract if there's 1, an investment of money, 2, in a common enterprise, and 3, with the expectation of profits to come solely from the effort of others. So in their analysis, they looked at prong 1 and said the judge said that the investment of Ethereum and Bitcoin does satisfy the first prong. It is an investment of money. Prong 2, in the common enterprise. So they did a little more analysis on this one. They said they also used that SEC versus Unique case, and as well as a Advanced Bus Concepts Corporation from the 11th Circuit, and they used a quote that said, "A common enterprise exists where the fortune of the investors are interwoven with and dependent upon the effort and success of those seeking the investment of third parties. The thrust of the common enterprise test is that the investors have no desire to perform the chores necessary for a return and are attracted to the investment solely by the prospects of a return." So what does that mean? It's kind of, to me, the common enterprise definition here it's kind of murky with the third prong, which is, the expectation comes solely from the effort of others. That's what they're saying is the common enterprise. So, but it says right in there, like, that's the crux of what a common enterprise is that someone else is doing the work and you're putting your money in a hope that you're going to get a profit off that. So then the third prong, Florida case law specifies that the efforts of others is the efforts made by those other than the investor that are undeniably significant ones, those essential managerial efforts which affect the failure or success of the enterprise. So, how can you argue for an ICO not to fall in this definition is pretty hard. Like, that is saying there, I've heard lots of people saying, well, if you give the community members some way to vote on the project or some way to contribute to the project, that it's going to pull it out of the securities definition that way by making it not just the success of one company, but by, the decentralized nature of having the whole community involved with the company's success. But practically, how does that actually work? And here they make it pretty, they say, which effect, the efforts made by those other than the investor that are undeniably significant ones. So I think going online and like clicking a survey or something like that isn't going to be a significant effort. It's essential managerial efforts that affect the failure or success of the enterprise. So That's from Baumert versus Polte Home Corporation, and it's 11th Circuit 2011. And they were quoting Williamson versus Tucker, which is 11th Circuit 1981. And they also say to look at the SEC versus Merchant Capital, which is 11th Circuit 2007. And that one, they quote, says, the focus is on the dependency of the investor on the entrepreneurial or managerial skills of a promoter or other party. So here, since the success of the Centra tech depended on the defendant's work, the third and final prong was satisfied, and voila, ICO tokens are now officially securities in Florida if they meet those three prongs, which is pretty hard not to. Unless you're game or something, like there is, it is certainly going to be a fact intensive inquiry. And I think Centra was a very low hanging fruit that they could go after, but bad facts often lead to bad laws. So since this one, the facts are egregious, it's easy to say, yeah, they're a security. These people are sitting in jail or wherever, waiting criminal trial. They're going to concede to anything. They're not fighting for the community here or anything. These are, fraudsters. They're not going to conduct themselves with any integrity. So, that's who's the people left to, determine whether or not ICOs, which is going to be applied to most ICOs, are securities. So this kind of sucks. Well, depending who you ask, some people want this classification so that ICOs will go away because they think that ICOs compete negatively with Bitcoin or lead to a lot of people losing money, and then that will hold up or slow down mass adoption, because Bitcoin's the only true decentralized cryptocurrency. So depending who you ask, some people are probably quite happy that this has come out, and they've been saying it for years that these things are securities. But it definitely is different than what the SEC said around Ethereum too, like only a couple weeks ago. But these guys, they're not going to be able to argue that they had a decentralized community or anything like that. They didn't file an answer yet, so who knows what defenses they're going to bring up. But they did file a motion to compel arbitration, which I haven't gone and read it yet, but it's on Pacer. I actually did ask my law clerk to pull it so I can read it tomorrow. But anyway, the fact that it's still in court means they probably didn't win on that. And the fact that I read somewhere else in the report by the judge, they didn't even have a arbitration clause that people had to sign anywhere. Maybe it was in their privacy policy, but I think they didn't even pull up. They had no evidence that they had any arbitration clause. So I put it in the privacy policy for my the terms of use. I typically put an arbitration clause in for my clients, and that should hold up because anytime someone clicks on something, then they're going to have these terms of use, and in there they're agreeing to arbitrate rather than do this publicly, which in certain cases, it's good. If you're the plaintiff, you want it in court. If you're the defendant, you don't want to be in court. So yeah, they lost that arbitration, or they must have lost it. And then the lead plaintiff didn't actually suffer any losses, which is the same thing that I noticed in the 3 Ripple complaints. Like one person actually had $600 loss. The other 2 had never sold the Ripple. They were still holding them. So they haven't actually had a material loss. So that's one of the elements, is that you have to show some kind of damage. So here, what this co-lead plaintiff is saying, he invested 16.1 Ethereum, which was worth 3,250 into Centra, and then he sold his Centra tokens for 0.709 Bitcoin, which was worth 3,517 at the time he sold. So from a US dollar perspective, he made money on this trade, and he's bringing the lawsuit. His argument is that because the Bitcoin he received on the sale of his Centra tokens was only able to buy him 13.723 Ethereum, he actually suffered a loss in terms of Ethereum. But that's not going to hold up, I don't think, because look at how we do the taxes. You just look at the US dollar value. We don't use these in terms of what other cryptocurrencies are. Imagine if this lawyer's got to be crazy to even allege this. Imagine if we made some kind of law that said, oh, anytime that any investment loses money in terms of any other cryptocurrency, then you have a case. Everyone would have a case every day, depending on the hour. Like, that would be crazy. I think the right way to do it is to look at the US dollar terms. And maybe some people out there are going to, or just look at it in terms of Bitcoin too. But making that argument just that it's in terms of Bitcoin is still, then why not in terms of Ethereum? It opens the door. And then why not in terms of Dash? Why not in terms of Monero? You know, any of them, it can keep creating that door. So until we're in a different world than we are today, I think US dollar makes the most sense. But the other co-lead plaintiff, he lost 206,000. So he had a huge loss. And the defendants, but he already suffered the loss, so that said he can't get rescission for it, but hopefully the government gives him some of those Ethereum they have sitting in their vault. So also, like the injunction or temporary restraining order, the judge said that the plaintiffs, they failed to prove the likelihood of actual and imminent irreparable injury, finding injunctive relief improper, but they did give some temporary precautionary injunctive relief that's listed in some separate order. So basically, I think it's probably just that those assets are frozen. And then in the conclusion, there was a major typo. They said that it was the defendant's order when it was actually the plaintiff's, or the defendant's motion to whatever, and then it was actually the plaintiff's one. So that was like, I guess someone was tired when they were typing that. And, you know, I've made mistakes on documents more times than I'd like to admit. Sometimes it's just hard to see when you're writing these things. And we all know what it means, but it's still pretty, you know, you shouldn't have on something like that. Like, they basically took the meaning of what they meant and flipped it on its head, saying that it was in favor of the defendants when it was actually in favor of the plaintiffs. So they did impose that asset freeze, and all of the defendants are enjoined from accessing the ICO wallet for any purpose other than complying with a valid court order, destroying, erasing, or otherwise making unavailable for further proceedings any books, records, accounts, passwords, computer passwords, device pins and passwords, cryptographic keys, any instrument data or paper, or anything relating to the ICO. So I wonder why they're asking for that. Maybe they don't have all of the Ethereum they have almost 100,000 Ethereum, and the ICO is for 30 million. I'm surprised there was that much left, but I wonder if they don't have the keys for it or something, and that's why they're asking that they don't erase anything, or if that's just like some kind of nonsense precaution, but they already have all the things they need. And then, so after this was filed on the 25th of June, defendants have 14 days to write objections, and then plaintiff has another 7 days to object to those objections. And if they fail to object to anything, it's gone on the appeal. You can't bring it up. So the overall impact or implication of this situation is it's just dicta. Like, this is words written by a judge, so they're more binding on court than the words written by the SEC in, you know, on their website or in notices, but it's still just dicta. Like, this isn't an actual trial. It's not something that people don't cite orders or reports so much. Like, they can cite it, but it's not going to bind anyone. So the analysis will probably be used as a future roadmap for other litigation. But the fraud in this case makes it really easy for the judge to go against the defendants, whereas then it could create really harsh law for companies that were not engaged in fraud but still did sell ICOs without registering them with the SEC. So there's still a lot of nuances that really need to be ironed out here. Maybe not. Maybe they're just all securities, but we'll see how it goes. Thank you.